Can you hear me? Good. I don't have a very good voice. It goes in and out because I talk a lot. My husband says that the more I talk tonight, the happier he'll be when I get home. I tried to meet as many of you as I could, but my name is Sheriff Fatheree, and I am the Summit County Sheriff. And I want to thank you for coming here tonight. We've been doing this now for a couple of years. And part of the reason why this happened is because in June of 2022, the laws changed from having a requirement for a permit for a concealed carry to what is known as constitutional carry. And as I traveled around the county, and I get around quite a bit, I had a lot of people asking me questions about the constitutional carry. So what I did was worked with the prosecutor to put together an information to be able to share, because there were so many questions that came up. I genuinely hope that at the end of the night tonight, that you have your answers to any questions that you have, that you feel comfortable with your ability to carry a weapon, and that overall, that you understand what the laws are and how they pertain to you. So I said the reason why I'm hosting this, and I'm trying to find a place to be that I'm not in the light there. There we go. The reason I'm hosting this is because the fact that the law did change. And I told you that a lot of questions were being asked. Concealed carry is a requirement of the sheriff. When I say concealed carry, to submit the license and do the background on you, constitutionally, and not constitutionally, in the Ohio Revised Code, it says the duties of the sheriff to do your background and issue your concealed carry license, okay? But with constitutional concealed carry, you don't have to have a license in the state of Ohio. Now, the prosecutor is going to talk a lot about where you can carry, where you can't carry. They're going to talk a lot about the places and the states that you can go into and not go into. I still, one of the things that we've done is you signed up for this class through an app online. For any of you who have a concealed carry license or want a concealed carry license, you can go through that same app that you signed up to come to the class, and you can actually fill out your application that way. But as I said, the sheriff of the county is responsible for the applications and issuance of all concealed carry licenses. So I want to talk to you about gun safety, and they'll talk to you about the law. So one of the things that, most of the reason why people have guns is because they want to feel safe. The Constitution says that you have a right to bear arms for you to protect yourself and your family. The thing about it is, if you're going to have a gun in your home, you should know how to use it. You should know who it is that you want to have access to it, and you should know how to store it. So the first question that you have to ask yourself is, what is the purpose? What is your purpose for having a gun in your home? Now I'm going to talk about your home, but even on your body when you leave your home. But what is the purpose of you having a gun in your home and in your possession? You have to figure out what that is. Is it for your home protection? Is it, and if it is for home protection, then you want to have that gun loaded. If you're going to use the gun for protection at your home, the gun should be loaded. If you have multiple guns, they should not be. So it's just some, I know this sounds common sense in some ways, but just some things that you should consider. If you have a gun in your home and you have it loaded, don't have a bullet in the chamber. And I'll come back to that in a second. The second thing is, do not have that gun underneath your pillow, and don't have that gun in the nightstand beside your bed. So the gun should be, if you're going to have it in your bedroom at night, it should have bullets in the mag. There should be nothing in the chamber, and it should not be within easy reach when you're partially asleep. So the reason for that is you want to put it like on the dresser or in the dresser right across from your bed. And the reason for that is if something happens in the middle of the night and you are startled awake, and if that gun is within seconds of your grasp, you may accidentally shoot somebody that you love. It could be a spouse, a child, a grandchild. So we encourage you to have the gun in the bedroom, but not where you can just reach over and grab it. I want you awake when you use that weapon. The other thing is, if there's not a bullet in the chamber, it gives you the milliseconds that you will need for, number one, your brain to wake up, engage, assess your surroundings, and if you see an actual threat, then you can rack the bullet into the chamber. And by doing that, then, like I said, it gives you just a couple of seconds for you to be fully alert, fully awake as you use that gun. And you know then exactly who you're pointing it at, and if you pull that trigger, you know that you're doing it, and that it's not a loved one that you're shooting. So I know that sounds kind of funny in a lot of ways, especially for you guys that have guns that you've had for a long time, but I really encourage you to take those few seconds, have that gun a little bit further away from you, so that you can wake up and be responsible. Because once that bullet leaves the chamber, it's unforgiving. You can't take it back. Part of the reason why I say that is because every year, more than 300 children are accidentally shot by themselves or somebody else with a gun in the household. 76% of kids in schools get their guns from their homes. So I want to talk about storing your guns. When you don't have it on your possession, if it's not on your body and it's in your house, if you are not using it, you need to store it. Any guns, additional guns that you have, you need to have that you're not using, and you can only use one gun at a time unless you're Annie Oakley, got a mouth going. You need to have the guns empty and locked up. You don't want someone else to be able to gain access to your guns in your home. So you can have them in a lockbox, you can have them in a gun safe. You can use a gun lock to go through the barrel and the handle. But you want to secure that weapon so that your children, your grandchildren, somebody else can't gain easy access to it. And I say that because the fact that with so many of these school shootings, I'm encouraging you to be responsible gun owners and not have your guns in a position where children can get them. They talk a lot about the biometric. You know, these gun safes, you can rapidly get to a gun, and just by using your fingertip. So some of the biometric gun safes are really pretty impressive. I encourage you to take the time, do some research, and see what it is that you want to do as far as what kind of a safe, gun safe that you want. The most important thing though is that somehow, some way, you have your guns locked up when you're not using them. And again, the gun that you keep in your bedroom, if you're not sleeping, you need to have that also kind of put in a place where nobody can get to it. The other thing is, your gun is your gun, and it's not a toy. And I encourage you not to show it off to others, not let other people touch it, play with it, unless you're out in a range or you happen to be fortunate enough to have a backyard that you're able to shoot. You don't want other people having access to your gun. So you have to identify who it is that should have access to your gun in your home. If it's going to be you and your spouse, or you and a child, adult child, but you just need to pay close attention to who has access to your gun. Your gun should be in a holster. I highly recommend it. It's not like on TV, where you see them and they take the gun and they shove down from their pants or the back of their pants. Some of these guns, they don't have locks on them, and some of them have hair triggers on them. Ladies, so if you're going to carry a gun when you're out and about, you can go on Amazon and buy purses that are designed for guns. You can go to gun stores and buy them as well. You can spend anywhere from $30 up to $500 if you want. It's up to you. But the purses have zippers on them, so that you can put the gun in the purse in a compartment designed for the gun, and you can zip it up. It's easily accessible for you, should you need it. And when you're not using it, they have locks on them. You can lock that gun right into your purse. Now, one of the other things I'm going to say to you ladies is, if you have a gun in your purse, whether it's a secured location or not, and someone tries to steal your purse, let them. Just let law enforcement know that you had a gun in your purse. But don't fight somebody over your purse because you've got a gun in it. But I highly encourage you, if you're going to carry a gun and you're not going to have it in a holster, ladies, get a purse that is designed to carry a gun. In the state of Ohio, you can carry your gun anywhere within the boundaries of the state of Ohio. There are other than certain locations that the prosecutor will talk about. However, if you leave the state of Ohio and you do not have a concealed carry license, constitutional concealed carry in the state of Ohio is only for the state of Ohio. It does not go into West Virginia, Pennsylvania, Michigan, Indiana, Kentucky. That constitutional carry that you have in Ohio is only for Ohio. So if you take that gun with you out of Ohio, then you have to abide by the other states' rules. And a lot of states don't allow you to have a gun without a license.
Good evening, everyone. My name is Elliot Kolkovich. I'm your Summit County Prosecutor. First, I really just want to thank you all for being here. Obviously, firearms are clearly a right, but it's so encouraging to see so many people take it as the responsibility that it is and come here tonight to learn more. So really, thank you so much for taking time out this evening, and thank you, Sheriff, for always coordinating these events. I want to introduce a couple of our speakers you're going to have tonight. Kevin Mayer here is the one who just left the gym. You tell him.
It is next door.
I know. Kevin's been a prosecutor in our office for over 20 years. You're not going to find a finer trial attorney in the county than Kevin Mayer. In fact, one of the last murder cases I tried was with him a couple of years ago. Next to him is Marvin Evans, who made the unfortunate decision to leave our office, and now he works for the county executive, and that's okay. But when he was with our office, he was my go-to guy for any carry concealed weapon questions. He used to teach, I believe, CCW classes to be certified, and you're not going to find a smarter guy on weapons law. I will tell you, as a prosecutor, the changes in gun laws and self-defense laws are probably what we grapple most with in our daily job. Is that fair, Kevin?
Correct.
The last 2 trials I had the past 6 years, 6 months, one a win, one a loss, one a murder, one a felonious assault, both involve self-defense claims. Invariably, at the end of this question, you're going to start raising your hands and asking a lot of questions of both Kevin and Marvin. It's usually my favorite part of the presentation, where we ask, well, can I shoot somebody if they do this? Can I shoot somebody if they do that? Can I shoot somebody if they do this? Can I shoot somebody if they do this? These are natural questions. They are going to give you their best answer. But I will tell you that when it comes to the law, it's something we are still learning as we go on, because we are constantly learning from juries what society finds to be acceptable under normal circumstances. But Kevin and Marvin are going to take you through that. I just want to thank you so much for being here tonight and taking the opportunity to learn from, like I said, 2 of the most well-regarded, intelligent people on gun laws in the county. So thank you so much. Kevin?
Thank you for coming out. The fact that you're here, I've been doing this for 2 years, and it's always a pleasure because everyone here, I know you're all good citizens because you're here. You want to learn. The people I prosecute, I was, for several years, I was on a gun grant, handling homicides, felonious assaults. They don't care whether they can carry a gun or not, legally, all right? Everyone here wants to know, because when the law changed, it didn't mean it's a free-for-all. We don't carry guns now. No. That's why you're here today, to make sure you can. Now, just a little bit of history. For decades, open carry was always allowed. And what that means, interestingly enough, is I could walk down the street with a rifle slung over my shoulder. That's open carry. It's open, the police can see it. You're not concealing it. So that was always allowed. This isn't allowed. You can't say open carry. No, you can't point it at people, but you're allowed to hold it. But carry conceal was always against the law. Now, little known fact, the FOP fought making it the law for years, and I get that. I'd be terrified as an officer walking up to a car, wondering if I'm about to be ambushed. So they weren't keen on the idea. But in 2004, the law changed in Ohio. And that law was, you can now get a license, however, there were rules. You have to go to the sheriff's department. You have to fill out a form. The sheriff does a background check on you. After all the boxes are checked off, and this is actually important for the new law, after all the boxes are checked off, the sheriff will announce to you, you can get a carry conceal permit. And they would give you a permit, all right? Now, Columbus threw the FOP a bone in all this. He said, yeah, we know you don't like it, but we're gonna make it a law. Anyone who has that card, anyone who has the right now to carry conceal, if you ever get stopped by the police, you must be proactive. When they approach your car, you must say, officer, I have a carry conceal license and I do have a firearm. Failure to do that would be a charge. So that was the one thing they got, okay? Think about it, now just forget it, because now the law's changed. In June 13th, 2022, Ohio became the 23rd state to become what we call a constitutional carry state. The law essentially says, it's an interpretation of the Second Amendment, saying, well, the sheriff can't tell us we have the right, based on the Second Amendment, to carry a firearm. And so the law was passed, which meant all of a sudden, many Ohioans became what is known as qualified adults. And that's what we're going to talk about here today. Are you a qualified adult? Because a lot of people who think they are, if you come to this class, you might find out you're not. Now, let's start with a simple one. In Ohio, you have to be 21. You have to be 21. If you're 18, 19, 20, it doesn't matter. You can't put a gun in your pocket and walk around. You just can't. Fun fact, Louisiana just became the 27th carry conceal state, or constitutional carry. However, slightly different. I don't see anyone here under 21? No one here under 21. Okay, in Louisiana, it's 18. That law goes into effect, interestingly enough, this July 4th. It got a little beyond. But it's 18 there. In Ohio, it's 21. All right? So at a bare minimum, you have to be 21 to be considered a qualified adult. Also, several other factors come into play. Let's see, we already talked about this. It's not retroactive. We actually charge people days before it. Permit system is still in place. It still applies to improper handling. You can get charged with improper handling. And this applies to handguns. There are restricted firearms such as rifles. Fun fact, even if you are a qualified adult, don't have a loaded rifle on the floor of your car. That's illegal. That's illegal. That's not considered carry conceal. You can have the firearm in your pocket. I've had people ask, can it be in my pocket in the car? Yeah, of course. It can be hidden anywhere in the car. As long as you're a qualified adult, it can be anywhere. People always ask me, can it be loaded? Well, if it's not loaded, it's just a paperweight, right? I mean, the point of having it is loaded for your protection, just as the sheriff said. So yes, if you are a qualified adult, you can have your handgun loaded and concealed in your car. You can have it concealed walking down the street in your pants or in your purse, as long as you are a qualified adult. Qualified adult equals permit holder. A person who is a qualified adult may carry a concealed handgun anywhere in the state in which the person has been issued a concealed handgun license, anywhere in which a person who has been issued a concealed handgun license may carry. State of Ohio will likely have the burden of proving someone is not a qualified adult. That's a legal issue for me to have to deal with if I'm charging you with something. The burden's on us to prove you're not a qualified adult, as opposed to you having to prove you're in fact a qualified adult. Hopefully it'll never come to that. But qualified adult, just to break it down, in Ohio, had you gone to the sheriff and had you done a background check and had the sheriff said you passed all these requirements, and there's a list of them, which we're going to go through, then you would have gotten a license. So qualified adult equals somebody who, if they applied to get a license, would have gotten a license. So before you go handling a firearm, let's just see if you would have passed that test. Let's see, who is a qualified adult? The right of a person who is a qualified adult is the same right as is granted to a person who's been issued the carry concealed handgun license. Qualifying adult is subject to the same restrictions as applied to the person who had been issued a concealed handgun license. If a provision requires a concealed handgun licensee to engage in specific conduct or prohibits a concealed handgun licensee from engaging in specific conduct, the provision shall be construed to be the same. Qualified adult equals a person who already got their license from the sheriff. If a provision pertains to the imposition of a penalty or sanction for specific conduct, it shall be also applied to somebody who was a qualified adult. In short, if you could get a permit, you are now treated as if you have one. That's all it means. But let's go through all the terms, which I'll get to in a moment. You must be 21 or older in Ohio, not prohibited under 18 United States Code section 922 G1 through 9. That's federal law. All right? Don't worry, there's not a test after this. That is federal law. Okay, so you can't be in violation of federal law as well. I deal with the feds on a regular basis, and it always amazes me how we have dueling rules. We have, in our country, we have 50 states, and each one has their own laws. But we also have the federal laws that bind us together. And under the rules, if you're in violation of federal law, under that section, which we'll show in more detail, you're not considered a qualified adult. Or you can't be, now this is the Ohio Revised Code, it's usually ORC, this is Revised Code 2923.13. If I remember correctly, that is having weapons while under a disability. What does that mean, having a weapon while under disability? I get a lot of these cases. It's people who have prior convictions for felonies of violence, like a felonious assault or an assault on a police officer, which is an F4, or felony drug trafficking charges. Those people, after they're convicted, those people cannot carry firearms. Even if you're 25. Oh, I'm 25. Okay, no, you're not. You're not. There are rules where you can apply to have it removed, but we're not going to get into those today. So that's what it means to have a weapon under disability. There's several other disabilities. And some of them are repeated. There's a lot of repetitiveness in these laws. Like one example is, if you've been institutionalized, you can't have a gun. You can't have a gun. If you are, I've only seen this one time, if you are a drug addict or alcoholic, you can't possess a firearm. What's going on right now in the news where that's applicable? Okay. That's an example. That's an example of somebody under a disability. That's just a different state's version of it. That's all. Let's see. You got to satisfy most of 2923.125. That is the section that in 2004 became applicable to you getting a license. That is the list of things that the sheriff's office had to go through before deciding to hand you a license. So, and we're going to go through all of those in detail. This is the federal law. You can't be in violation of this federal law. It's unlawful for any person to have a gun if you've been convicted of a crime punishable by a term exceeding 1 year. Interestingly enough, I remember we used to have 4 levels of felonies years ago. In 96, 97, we added an F5, which is punishable by up to 1 year. So technically F5s don't count because it's up to 1 year, and this says exceeding 1 year. You can't be a fugitive from justice. If there's a warrant out for your arrest, and you know about it, that's more of my problem, you can't have a firearm. You can't. You might have been qualified before, but once you become a fugitive, you cannot. Let's see. Is an unlawful user or is addicted to any controlled substances. The Hunter Biden law has been adjudicated mentally defective or has been committed. So that would be if you've been probated and you have somebody who doles out your money, pays your bills for you. You can't just say, oh, this person's crazy. It's legally defined. So let's see. If you are an illegal alien, you cannot be a qualified adult. If you've been dishonorably discharged from the military, in Ohio, you cannot be a qualified adult. If you've renounced your citizenship, I don't really know anyone who's done that, but if you have, you're not going to be a qualified adult. If you're subject to a protection order, if I get accused of harming my wife, just to give you an example, and there's a protection order saying I can't be anywhere near her, I now can't also have a firearm until that protection order goes away. And there's multiple types of protection orders. There's temporary protection orders while a case is pending. There are civil protection orders which go for 5 years, things of that nature. Let's see, has been convicted of any misdemeanor domestic violence. So even if you've had a misdemeanor DV under the federal law, you can't be considered a qualified adult. We touched upon this, 2923.13, weapons of disability. No person shall acquire, have, carry, or use a firearm if you're fugitive from justice, under indictment, or convicted of a felony offense of violence, under indictment for or being convicted of a felony drug offense. It could be felony possession or felony trafficking. Or if you are drug dependent, or if you've been adjudicated mentally incompetent or defective, or you've been committed to an institution. Under those circumstances, this is Ohio law. Now, you probably did notice a lot of it's repetitive. The federal law has some of this, so does the Ohio law. But all of these, if any one of them applies, even if you're over 21, if any one of them applies, you're not a qualified adult. At this point, I wait and see who gets up and walks away. No, okay. Good. All right. The applicant, now this was the application to the sheriff's office. And by the way, you can still apply for a permit. As the sheriff said, you might want to go to another state. You might want to have that carry concealed permit. And the bonus of going through the sheriff's office is they actually teach you how to fire a gun. I'm a huge fan of the Second Amendment. I respect it. It scares me that anyone can now just walk into a gun shop, buy a gun, and shove it in their pocket. There should be some training. There should be some. But constitutional carry. So the fact that everyone here is actually here, that means you're probably all responsible and you're learning how to handle your firearms. That's wonderful. Let's see. So this is, under the original law, this is all the things the sheriff's office looked at before handing you a permit. And now, you still, to be a qualified adult, you still have to pass all this. So it's good you're here today so you can read this and make sure one of these is not applicable to you. You must be 21, that's the easy part. Legally living in the USA. Not be under indictment or otherwise charged with a felony, a drug offense, misdemeanor offense of violence, negligent assault, falsifying or possessing a revoked or suspended carry concealed permit. All right. So this, keep in mind, this is only under indictment or charged. This doesn't talk about convictions. So when this law was written and the sheriff's office was looking at you as a possible candidate for the permit, they'll check and go, oh, wait a minute, you have a pending negligent assault. You haven't been convicted yet, but it's still pending. We can't give you a card. If you go to court and you win, that part goes away. But this is just indictment or otherwise charged. You can't be adjudicated a mental defective. We're going to hear that one a lot, which is probably a good thing. Not have a suspended carry concealed permit for a misdemeanor conviction. So if you had a permit and it got revoked or suspended, then you're not going to be a qualified adult. Not have convictions for a felony drug offense. That sounds like 292313. Once again, it's repetitive. An assault on a police officer, that's an F4. If you punch me and you give me a black eye, that's an M1, because I'm nobody. If you punch a police officer, that's an F, same harm, that's an F4. So that would fall under that, an assault on a peace officer. Any misdemeanor punishable by imprisonment greater than a year, and in Ohio, M1s go up to 6 months. A misdemeanor offense of violence within the last 3 years. So if you had an M1 assault 2 years ago and 300 days added onto that, you got to wait like 4 or 5 days. So after 3 years passes, you magically become a qualified adult at that moment. So that's what that means. You can't have a misdemeanor offense of violence within 3 years. 2 or more convictions for assault or negligent assault within 5 years. So if you had those, this is at the moment you decide you want to carry a handgun. Are you a qualified adult? Well, you're not if you've had 2 or more convictions within the last 5 years. Resisting arrest within 10 years. If you didn't get along well with the police and you resisted arrest, under the law, we didn't want you having a gun. And if you had it 9 years ago, that conviction, because notice this over here says under indictment or charged. All of these are actual convictions. You were found guilty. That's what it means. So if you have a resisting arrest conviction that's 9 years old, you gotta wait 1 more year. And at that point, you magically become a qualified adult, unless something else applied. You cannot be subject to a protection order. We've been through that. Not have been dishonorably discharged from the military. Once again, it's a little bit redundant, but these laws all apply. Changes for permit holders. If you already have your permit, good for you. But when the law changed and you had a permit, not much change. All it means is you're no longer required to carry your permit. Because before the law changed, if you wanted to carry a gun, you better have your permit with you. Show the officer, I have a permit. But the moment you became a qualified adult, when the law changed, you can leave your permit at home under those circumstances. Now you only need to disclose if asked by law enforcement. Remember that bone I told you that they threw the police and said, oh, we're gonna allow people to carry concealed, but if you stop them, they must immediately tell you they're armed. That's gone. That's gone. All right. However, because I go around and lecture to police departments too, and I explain to them, remember the old adage, if you pull over someone, you walk up to a car, what do officers say to you when they walk up to a car? License and registration, right? Let's just assume it's a traffic violation. License and registration. What did they add to this now? License, registration, and are you armed? Are you armed? If you lie to them, it's a crime. But the old rule of you having to be proactive and tell them, that's gone. So now they're gonna ask you, are you armed? Yes, sir.
Is our concealed carry from them automatically linked to our license plate so that when they stop us, they already know that we have a CCW?
I have no idea. Probably.
Yes.
I'm hearing yes. Oh, there you go.
I can answer, yeah, when we run your driver's license, it's not attached to your license plate, it's your driver's license. When we run your driver's license, leads will tell us if you've got a CCW.
But for everyone else who just magically became a qualified adult last June of 2022, it would not. So, yes.
It's linked to any car you own though too. So the registration, my understanding is it would flow through the registrations, is my understanding. So any car that's in your name is going to be linked to that too.
But just so we're clear, that's if you had a carry concealed license.
Right, a license issued by the sheriff.
Not everyone's going to ring qualified adult. So, yes, sir.
So if you have an interaction that doesn't involve a traffic stop, which automatically have to identify yourself and registration and insurance, how are you training your officers to approach people? Like if I'm walking my dog and I have my Glock on my hip and the neighbor calls and the police roll up, how are you training your officers to handle that interaction?
Well, I will tell you this much, because I teach at several police academies. There's 3 types of encounters citizens can have with police. One is if the police have what is known as probable cause, you're under arrest. The next one down is known as a Terry stop, Terry versus Ohio. If they have reasonable and articulate suspicion that criminal activity is afoot and you're involved, they're allowed to briefly detain you. They're not allowed to take you to a station. They're allowed to get your information. And under those circumstances, they're gonna ask you if you're armed. And if they have, here's the kicker, if they have a reasonable and articulate suspicion that you're armed, they're gonna search you anyway. You're not busted if you kept your mouth shut because the law doesn't say you have to. But if they ask you if you're armed, that could be another problem. The final type of encounter is just consensual encounter, meaning the cop's looking at you, has a gut feeling. Something's not right, but that's nothing else. They're allowed to come up to you and talk to you, but what are you allowed to do? You're allowed to go, no, I don't want to talk, have a nice day. You don't have to say a word to them. And they don't get to stop you. You get to keep walking. So those are the 3 encounters. I would say 2 of them, if you lie to the police, especially during arrest, that could be a charge. Oh, I did lie, there is a test. Okay. Hypothetical, Wild Bill is at the upper deck. He has a loaded handgun concealed in his waistband. So the upper deck is a bar over there, I'm sure you've all been there. No? Okay. So he's got a loaded handgun concealed in his waistband. He does not have a carry concealed handgun permit. However, he is a qualified adult. So the first question is Bill permitted to carry the loaded handgun in a bar? No. Was it the look on my face? Come on, you had a 50-50 shot at it. The answer is yes, unless unless the bar has a sign saying no guns. Yes.
If they have, I've heard that if they have a class B or above liquor license, you're still not allowed to carry your premises.
Bars can allow that. They can allow you to carry a gun.
Okay.
But they can also say not. The stores can say not, all right, as far as that goes. But yeah, he can carry it. Would your answer change if he's intoxicated?
Yes.
Yeah. There are several bars where I can walk in, but I can't drink. I can't drink. What if he's just drinking beer? Damn. That would have been useful last year. No, I'm just kidding. No, just drinking one beer. It's hey, you could be in here with a gun, but you can't have any alcohol. So if an officer sees you in the bar drinking and you got a gun and you say I'm a qualified adult, you just violated the law. Let's see. Wyatt Earp is traffic stopped for an equipment violation. Officers smell marijuana. During their search, they find a loaded arms AM-15 on the passenger floorboard. Earp does not have a carry concealed permit. However, he is a qualified adult. Is Wyatt allowed to carry the loaded firearm on his passenger floorboard? No. Why not?
He wasn't correctly.
Well, I like the way you think. No, he's not allowed. Remember we talked about this early on. This is about carry concealed handguns. You can't, if you want to carry a rifle, you take the magazine out, you put it separate, the ammunition separate. Like, we've seen trucks with gun racks, right? Hunters. Mm-hmm. You can have that, but there better not be bullets in there under the circumstances. That's what that means. Same question, but now it's a handgun. Is he fine?
No.
Why not? So what?
Yeah, but it doesn't mean he has it on him.
No, he has the gun on him. He has the gun on him. The only thing we changed about this thing is they smell marijuana, and he has a handgun.
The marijuana could be coming out from outside the car as the officer passed by. How do you know? It was inside the car.
I work at the probation department. Everything smells like marijuana. The answer is we're fine. The answer is he's fine. Okay, now what if we find marijuana too, but he's not impaired? I had to talk to other people in my office when all this happened because what's the answer? We don't know. I can tell you now, it doesn't matter. It's okay. It's okay. What if they find cocaine?
Controlled substance.
You're going to get charged with possession of cocaine, but it doesn't affect your ability to carry a concealed handgun. All right, actually later when you become convicted of because cocaine is an automatic felony, and once you're convicted, now you are under the disability under 2923.13, and now you're not going to be considered a qualified adult. But at this moment, you were fine. There's nothing we can bust you for yet because you haven't been convicted yet. Yes. What about it? Back in the old days, over 200 grams was a felony. How much can I buy in a store now? I don't even know. I don't. You know what? My understanding is it doesn't matter if there's marijuana. It doesn't matter if you have a lot of it. If you have levels of it that's indicative of trafficking, because with the new laws in Ohio, we're at medical level now, but it's becoming recreational, right?
Soon, yeah.
Soon. Okay. All right. But there are rules there that could cause you to get charged with something. But once again, I would be concerned with conviction. If you get trafficking in marijuana conviction, that would apply under the weapons under disability section, and you'd no longer be a qualified adult under those circumstances. What if he's actively smoking marijuana at the time? Like every movie. Is he?
Well, sure.
Is he?
Don't you have
I
to
used to
be
be a
on the
defense attorney, and when I used to ask juries, is it legal to drink and drive?
Well, the time you put alcohol to your lips, aren't you considered intoxicated?
So if I have one beer, can I get in my car and drive away? I can't?
It's only legal.
Man, you're tough. The answer is I can't. I can't. I can drink, if one beer does not put me under the influence, Okay, now in Ohio, we have 4 different laws. We have the subjective law under 4511-19A1 that says you're under the influence, and that's gonna be based on the tests you do and everything. And the A2, 3, 4, blood, breath, urine, it's illegal to have a certain concentration in your body no matter how well you do the test. If you have too much in your system, you're gonna get tagged for that. So to have one beer, it's not illegal. No cop is gonna bust and go, you had a beer. I'm not talking open container, I'm just talking about drinking a beer and then getting in my car.
Yeah, but that's a contradiction. If you're in a bar and you're carrying, you're not allowed to put anything to your lips that has alcohol. So why should you be allowed to do it in your car?
No. Let's assume for a minute for this, that he went to a bar, didn't have his gun was in the car, drank in the bar, got in his car, drove away, got pulled over.
Okay.
As long as he had, let's just assume 1 beer. I mean, let's assume he's not a lightweight. Okay, so under those circumstances, he'd be fine. He would be fine.
But see, I'm alluding back to the point that you were saying if he was smoking marijuana in the car.
Right in front of the cop.
Okay, that's the same as taking a drink in the bar if you're carrying a gun, isn't it?
Arguably. And you know what we need? I'm glad you brought that up. Because when this law passed, and I teach this at the academies, and one of the things I always tell all my classes is, go forth, go out there and make new case law. Okay, no, I am 100% serious. Because out there in the world, the legislature in Columbus makes laws, and then a bunch of people go, well, what about this? What about this? I don't know, let's have a judge decide. So go ahead and try it, let's make new case law. Proving that he had 900 nanograms per milliliter of marijuana metabolite in his urine. I can tell you that's the legal limit for, I talked about blood, breath, and urine, that's the legal limit for marijuana in the urine. So he's over the legal limit, so he would be in trouble for he would be charged with the F5 version of improper handling of a firearm in a motor vehicle. Under those circumstances, it would be a felony, even though this could be a misdemeanor. He'd have a misdemeanor OVI, and he'd have an F5 felony, improper handling of a firearm in a motor vehicle. Let's see.
What was the answer to number 5?
Let's go back. Number 5. What if he's actively fine? I think he's fine. I think you could be charged. You can be charged with marijuana charges. I don't believe. Once again, I don't want to say it's beneath me, but it kind of is because it's marijuana. Smoking marijuana in a car. That's still illegal.
It's illegal.
Yeah, it's still illegal for now.
Yeah.
For now.
It's still going to be illegal later too. You cannot smoke marijuana while you're driving.
Just like you can't drink while you're driving. I'm assuming they're going to treat it like alcohol.
Yeah.
So,
Absolutely.
what about gummies? Can I be popping gummies? We could be here all day talking about that. You know, but to answer your question, I don't think it's going to be I don't think you're going to lose your qualification. You're not going to become an unqualified adult as a result of that happening. Let's see. Billy the Kid is out of apples. He goes to the Giant Eagle to restock and takes his favorite 6-shooter with him, concealed under his jacket. So it's a handgun, it's concealed. There's a sign at the entrance pursuant to 2923-1212 stating, unless otherwise authorized by law, no guns allowed. Now Billy is in fact a qualified adult. If Billy does have a permit, is he allowed to carry? No, he's not. Well, he's the funny story. This became an issue during the protests. There was a big memorial at the Knight Center, and I got a phone call the night before, and they said, "Hey, there's a sign there, prominently displayed, saying no handguns." And the question was, what do we do if we catch people with handguns, Kevin? And I'm like, oh, I don't know. So I grabbed the code book and I looked it up. And I called back and said, it's akin to a trespass. It's a trespass. If you invite me to your house and you see I have a gun stuck in my waist belt, they go, no, I don't want guns in my house, Kevin. I'm like, yeah, I'm an American. And I come in your house. I just trespassed. It's an M4 trespass. Punishable by up to 30 days in jail. Okay, so the only thing lower is a minor misdemeanor, which is speeding and things like that. So if you do go into stores now here's the trick though. and this is what I explained to the higher ups when I read the statute that night. I said, the signs must be prominently displayed. You, because you're allowed to carry guns, but if you don't know you can't carry it in there, then how can you be in trouble? So the law says must be prominently displayed, somewhere where you could see it. I mean, you might try to make a defense going, I didn't see it when I walked in. You know, that's why we have juries. So under those circumstances, it's akin to a trespass. And we had people show up at that, and they saw the sign, and they turned around, God bless them, they went back and put their guns back in their car. And then came back in. We followed the law. Bottom line, if you could get a permit under the old law, where you went to the sheriff, under 2923.125, subsection A through S. You don't have to memorize that, don't worry. But if you could get a permit, you are now treated as if you do have one. And that was the whole point of this exercise, looking at all the things that all the hoops you would have needed to jump through to get a permit. You no longer have to jump through those hoops. But if we discover that you would have failed jumping through those hoops, then you're not a qualified adult, sorry. So it's clear as mud, right? I mean, you can get this printout and look at all those things. I mean, I'm sure all of you saw this. That doesn't apply to me. That doesn't apply to me. That doesn't. I'm sure you're all golden. Yes, sir.
Yeah, so if you pick your kid up from school each day and you have a gun in your car, you're allowed to carry it. Do you have to leave that gun at home to go to that school?
We've had this discussion too, didn't we?
Yeah, if you have a license issued by the sheriff, you can go on school property as long as the gun does not leave the car. So you can drive your car onto the property, the kid can get in, but if you get out of the car, the gun has to stay in the car. You have to have that sheriff. This is really the only exception to the qualified adult equals licensee, is because under federal law, you have to have a license issued by the sheriff or a political subdivision of the state or the state to be able to go on the school property. So if you're only a qualified adult, you can't go on school property. You don't have that same right because of federal law. Does that answer your question?
Unless case law changes that, which you're right. We should change that because I always thought qualified adult equals permit holder. One exception, right there.
But that's different for constitutional carry, is it not?
Well, that's what I'm saying. If you don't have a license issued by the sheriff, in the situation of going on to school property, you are not allowed to do that because of federal law, but it also makes it illegal under Ohio law. Because there's a twist in Ohio law says if something is illegal under federal law, it is also illegal under Ohio law.
That's a catch-all.
It is.
And it's an actual physical.
Yes, it's issued by the sheriff where you go in, make the application, pay your money, and they issue you a license.
As for the school zone, I thought the inside of your vehicle was considered private property. So as long as you don't carry anything out of the vehicle, it's still on your premises.
If you're on school property and you've got a firearm in let's talk about handguns. If you've got a handgun in your car, you're on school property, it doesn't matter that it's your property. It's illegal under federal law unless you have a license issued by the sheriff.
Well, I don't know if you're saying, can they go in and search it? The answer is no, but under the doctrine of plain view, if they can see through your window and see it, that's a different issue altogether. Okay. Yes, ma'am.
So there's a gray area between the Ohio law and federal law, but always defer to federal, if it's a higher law.
No, they'll just defer, if one's saying you can and one's saying you can't, the answer is you can't, be it state or federal, under those circumstances. That's what it means. Yes, sir.
When it says, I happened to download the handbook, the youth handbook, and it talked about you cannot carry a gun, I believe it said in a church.
Right.
Now, does the church have to have a sign, or if it's a church, that's it, you can't carry?
You can't carry it in the church unless they allow you to. That's the law on that. in a church, it's illegal unless they allow you to.
Thank you.
This isn't Texas. Okay. Anyone? All right, what? Thank you for your time.
Okay. Oh, boy, that gets loud, doesn't it? Can you hear me back there if I talk this way also? I may use that, my voice doesn't last as long as Kevin's. He does trials, that's why he does it. His voice is much stronger than mine. And the reason I left the prosecutor's office is because they made me wear a tie. So.
My boss was here. I thought they did.
So now what we're going to talk about is we're talking about obviously carrying, licensing, and things like that. Now we get to the really fun stuff. You thought that was confusing before. Now we're going to talk about some really confusing stuff of actually using your firearm in self-defense. Because this is going to be, there's all kinds of gray areas, but again, feel free to ask questions. I think we have plenty of time. It's not even 10 till, so we've got a good 40 minutes. So I've got 4 slides to go through related to the basics of self-defense. Let me get through those because it'll give you the basics. As you probably saw in the AG's handbook, it basically has the similar information. I would say for you, if you don't have it, get that AG's handbook. It's on their website. If you Google Ohio Attorney General CCW handbook, it should be basically the first thing that pops up. It'll give you this information in a basic form, really well written. It's good to have that, so please get it. So, use of force, to begin with, you can only use reasonable and necessary force in self-defense. This is just like police, they can't use excessive force. Same applies to you. That's what I'm talking about. You can't use excessive force under the circumstances. You can defend yourself until any risk is neutralized, but every situation is going to be different. We'll talk about that a little bit later. And sure, Kevin, the sheriff, we got some other people from the prosecutor's office. There's all kinds of stories. You can get all kinds of different scenarios, but there's all kinds of gray areas involved, and so many of these cases depend on the circumstances, the facts. Every little fact can lead to what is a proper use of force and where isn't it proper. So that's let's see. We'll talk about, these are the basics of the elements that a prosecutor is going to look at and the police are going to look at to say, if somebody's claiming self-defense, they're going to look at first at these elements. The first is, was the defendant at fault for creating, prolonging, or escalating a situation? Creating is obviously pretty easy to think about, but the prolonging or escalating, that can be a whole different situation. You get in a fight with somebody, argument, it just keeps escalating and escalating until it becomes a physical altercation. Then it starts getting really difficult to figure out who's right and who's wrong. But that's the basics. These 3 elements are pretty much standard across the United States. These are kind of the traditional 3 elements of a self-defense defense. So you didn't create it, you didn't prolong it or escalate it. You had a reasonable and honest belief of immediate danger of death or serious bodily injury, and your only means of escape was to use deadly force. So, think about that. It has to be immediate. It can't be somebody is threatening to shoot you next week or next time they see you, or they're getting in your face, yelling at you, saying, I'm going to kill you, but they're not doing it. Their hands are behind their backs. You see no means for them to do it. Is there really an immediate risk? The basic element. Then the last one, which is typical in a lot of states and was the law in Ohio until a few years ago, did you fulfill your duty to retreat if there was one? So before the law changed in 2019, if you were on the street, you were say you did have an argument and it got too far and you could retreat, safely, you had to do that before using deadly force. Now, Ohio's a stand your ground law, says you can stand your ground. How that's going to play out in a lot of situations is going to be difficult to say, because it, certainly it could impact the other two elements, even though juries are not allowed to even consider whether you could retreat or not. Kevin may have some views on that. I don't know that we've seen enough cases yet to know how that's fully going to play out if somebody's really standing their ground. So those are the three traditional elements of a defense where you say I was acting in self-defense. So that reasonable belief, it has to be, there's two elements to it. One is it's subjective based on your own circumstance. So think about, this may be something only you know, or it may be just your circumstance. Somebody that's, Kevin's a big guy, he doesn't have to worry about, frankly, somebody coming up and punching him. He's probably nobody's ever going to do that with Kevin.
These guns are legal.
Yeah. But say you're an 80-year-old person that's has shrunk down over the years, and you're much different.
66-year-old, 5'4",
There you go.
135-pound female.
Yeah.
And if we added that I've had knee surgery or something like that.
Yeah.
I haven't, but.
Yeah, but you can run like the wind. So but it's going to be based on your own circumstances. So all that stuff comes into play. Your physical makeup, if you have a condition that is particular to you, say you're a hemophiliac, you've got a metal plate in your head that if you got punched, it could kill you, or it's going to kill you if that happens. So you can have particular types of things that are particular to you that somebody on the street may not know. You could be, somebody like Kevin's size, but if he was a hemophiliac and he got punched, he could easily die. Or if he's got a heart condition, he knows if I got punched in the chest, I'm likely to die because I just had surgery or something like that. So that will all come into play. Then there's an objective test, and kind of where this comes into play is, this really comes from the jury instructions on this element, is the jury says, this person is claiming self-defense. You need to look at that person's own circumstances, look at all the circumstances that were surrounding this whole incident on a subjective basis, and make that determination of, did that person have a reasonable and honest belief that their life was seriously being threatened, or there was a threat of serious bodily injury. Then the jury's asked to, on the objective piece of it, look at what was the circumstance with the person that got shot, let's say the aggressor in this case. Would a reasonable person have viewed their behavior as being that they were threatening somebody's life or serious bodily injury? So they look at both elements. They look at the person that did the shooting, and they did look at the person that got shot to say, as a reasonable person, would you believe this person was going to kill this person or, give them serious bodily injury? So that's the standard. And as Kevin was saying, this is subject to the state's burden. The state has the burden of proof in all these cases. It used to be, up until a couple years ago, that in self-defense, the person claiming self-defense had some small amount of a burden of proof. They had to prove by preponderance of the evidence that they were acting in self-defense. So they had to bring forward some type of evidence. Now, if they even bring forward a minimal amount of evidence that they were acting in self-defense, the prosecutor has the burden of disproving that. Now, they can't come forward and just say, I was just acting in self-defense. Although that may be, depending on circumstances, may be enough. But they may have to bring forward some little bit of evidence. Some of the case law says it is very minimal. But to get past the law that says, you know, to claim self-defense, I don't know if you can explain that better than I, because you probably had these cases.
When the law changed a few years ago, unfortunately I found out we had it too good for too long. It used to be the burden was on the defendant to prove self-defense. I didn't realize this, but all the other states had it the other way around, where it was always the state's burden. And we finally changed it to now it's the state's burden. And I will tell you that once that happened, multiple defendants came forward and claimed self-defense, self-defense, self-defense. Last week I got 2 notifications of self-defense. By law, they had to notify us 30 days out. They gave us, they officially said, this is self-defense. Because they know, now it didn't help them, we still convicted. But the law is on us to prove that it was not self-defense. And in this day and age, there's only 2 defenses to murder. One is, I didn't do it, it wasn't me. The other one is, okay, it was me, but it was self-defense. With technology and videos and phones, where we can put you right at the scene, most people are switching to self-defense now. Yeah, but that's how that works.
So threats and words alone are not enough to use deadly force. If you're not using deadly force, you can defend yourself. So, you know, don't be if it's just, frankly, if it's just a fist fight, you know, you can defend yourself. When we're talking about deadly force, though, it is a much higher standard. You have to have that threat of your life or threat of serious bodily injury.
When it comes to, I can tell you this for purposes of trial, when it comes to definitions of self-defense, the jury instructions, what the jury gets to figure out whether it was or not, multiple pages, multiple rules as to, you can't claim self-defense if you were the initial aggressor and you did not retreat from the situation. There's multiple rules as far as self-defense goes. But what you're talking about here today, I'm guessing we're really just focusing on home or even walking around.
Walking around. I mean, this basic stuff.
Yeah, because people are afraid now. I saw, to give you an example, the bodega worker in New York who stabbed that guy who came around the counter and started beating the hell out of him. I watched that and I said, what's the problem? He was charged. They eventually dismissed it once the prosecutor finally called out, like, we're not going to convict this guy. You know, but we can't, unfortunately, we can't sit here and give you black and white. It's going to be gray. It's going to be the circumstances, whatever's playing out in your scenario. You know, you have to have an honest fear, and it has to be a reasonable fear under the circumstances. Now, bonus, if someone's in your house uninvited, okay, there is a presumption that the force was reasonable.
Yeah,
It's not 100% automatic. If a Girl Scout comes in my house by accident and I shoot her, you know, it's not gonna work. But that's just an example.
Yeah, we're going to talk about that. We're going to talk about the castle doctrine too. After we get the basics of self-defense, because that's an exception. It's got some other rules related to it. But despite Ohio's stand your ground law, certainly if you can safely walk away from a situation, do it. You don't want to be in a situation where, you know, I could have walked away from this, or run away from it, however that would work out. But no, I decided to sit here and shoot somebody. It's going to change your life. I mean, let's get real. You know, stand your ground is one thing, but, you know, actually doing it, and you may have to go through a lot of headaches for a number of years before you're exonerated. So if you can walk away, do it. As I talked about, the state has the burden of proof, and they need to prove it beyond a reasonable doubt. The accused, and if there is this just a minor amount of evidence, it has to be something, but probably more than nothing, that you acted in self-defense. They're going to have to prove that you didn't act in self-defense. And remember, in Ohio, you don't have to do your retreat, and but that's if you're in a place where you have a lawful right to be. Now, just think about that, because the statute actually says that you have no duty to retreat if you're in a place where you have a right to be. What if you're trespassing? What if somebody has told you to leave their house, and all of a sudden now you say, well, I'm not leaving, because I'm drunk, and now you get in a fight and something happens, that could change the whole scenario here. And frankly, that's where you start reading some of these murder cases where people are claiming self-defense, and a big percentage of those, you'll see, it's people that are partying together, getting drunk, they have a fight, and all of a sudden things go south, and somebody pulls out a gun, and somebody gets shot. And so that happens quite a bit. It's, frankly, if you look at a lot of these cases talking about self-defense, the overwhelming majority of them are people that know each other and have known each other for years sometimes. And they party together and they get drunk together, and one night things go south. So it's, those are the situations you gotta be really careful about. Yes?
I have a question, because the presumption has always been that you're being under threat with somebody with a firearm. What about if a guy pulls out a baseball bat or a knife? Where do you draw the line on the consideration that your life is a threat?
Well, that's a tough
It
situation,
doesn't
but.
change much. If you come at me with a bat
Yeah.
or a knife and I have a gun,
Yeah?
can you kill me with that knife or bat?
Yeah.
Yeah, so under most circumstances, and I can't, like I said, it's gray, but if you're coming at me and it's clear you intend to cause death, or the code says death or serious bodily harm. Okay, if I can, most likely, in most cases, I should you defend myself, because you're coming at me, and I'm assuming I'm standing where I'm allowed to be standing, and stand your ground. Under those circumstances, I believe I would not get indicted. I cannot say automatically, because any case can still be reviewed. But once again, you wanted to change it to knife or bat, I'm telling you, it depends on what you're doing. If you're just standing back here with a bat doing this, I can't go, oh, boom, but if you're like, you can kill me with that.
Yeah, same with knives. I mean, even the box cutter type knives, people will say, oh, that knife is so short, but that will certainly kill you if you hit the right artery. It will certainly disfigure you, which is a part of that serious bodily injury. The statute actually lays out, I think it's 5 or 6 types of things that are serious bodily injury. One of them is causing you some type of serious mental injury that would require hospitalization. So obviously things like rape, abduction, something that will cause serious or permanent disfigurement, things like, somebody's threatening to, and it looks like they are going to break both your knees. It would cause you to become disabled potentially for the rest of your life. That would actually fall under the category of serious bodily injury, and the statute actually lays those types of things out.
And I think it's important to note, just to give you another example, I know we didn't touch on it yet, but you can actually defend third persons, not just yourself. Maybe most of you remember the situation in Columbus a couple of years ago. An officer had to shoot a young lady who was making the stabbing motion to stab another young girl. She was like this. He took out his gun and fired. No charges. Now, obviously, sometimes situations are different with officers because they have that to force to be in the situation. But under those circumstances, he was definitively defending a third party. And that person didn't have a gun. The person who shot did not have a gun. She had a knife, and she was raising it, and it was coming down on that other girl. And that was the moment that officer shot that gun. It infuriated me that people were having an issue with that, because, I've seen some of these cases that was 100% justified.
So that's kind of the basics of self-defense. Are there any questions you have related to that? Because otherwise, then we're going to talk a bit. I got 3 slides on castle doctrine. Okay, so those were the basics. You kind of understand. You have to have the 3 elements. You didn't start it. you had a reasonable honest belief that your life was in danger or serious bodily injury, and that's your only means of escape. And if you had a duty to retreat for whatever reason, you fulfilled that. But you normally don't have that duty. So with the castle doctrine, the castle doctrine applies to, under statute in Ohio, it applies to your home or a place where you're staying, say overnight, that would be considered a home, hotel room. The statute even says a tent, says an attached porch to your house. So those types of situations, I think there is actually case law. Say if you're staying overnight at somebody else's house, you would fall under the castle doctrine if something actually happened, assuming that you're not shooting the owner of the house. You know, we're talking third-party people coming in. So in Ohio, by statute, it varies by state. So if you go to another state, you know, when you're looking up the laws to see if you need to have a license or not, have a quick look through. You know, if you're going to be there for a while and you have your gun with you for self-protection, find out if they have a castle doctrine. Some states do, some states don't. It may vary as to what's really covered. I don't know if some of the states may say, hey, if you're not a resident here, it doesn't cover you. I don't know. So if you're in a hotel room, it may not cover you. It's not that you wouldn't be able to protect yourself. Let's put it that way. Castle doctrine has really nothing to do with saying, can you or can you not defend yourself. It actually just gives you an additional layer of protection if you are using self-defense in certain situations. That's how you should look at it. You should always be able to defend yourself, and if you're in your home or in your car, which is also in the Ohio statute, you actually have an additional layer of protection. As Kevin had said earlier, what it provides is if you're in those circumstances, so in your home, your car, and somebody comes in that has no right to be there, that if you use deadly force in self-defense, you're presumed to have acted in self-defense. It doesn't give you unfettered right to use deadly force in circumstances. So, for instance, there is case law out there. We're talking about, and I talk about people, getting together and partying and getting drunk and all that type of thing. That does happen quite a bit. So this happened in a case, I can't remember if it was Columbus or Cleveland. Guys are having a big party. Guy comes in. He had to leave really quick. He got mad about something, and he had been in this guy's house numerous times. They've been friends for years. And the guy that got shot, the owner of the house told him to leave. He didn't leave right away. And actually he made things worse by, I think he pushed somebody. The guy pulled out a gun and shot him. He said, well, I was defending the woman that he pushed. And he said, I want to invoke the castle doctrine. The court says, nah, that's not what the castle doctrine's for. It's about somebody coming into your home that is completely uninvited, that doesn't have a right to be there. This type of situation where you told somebody to leave, they don't leave, and now they're a trespasser, but at one point they were an invitee. You had invited them to your home. The castle doctrine didn't apply to him. Now, if it was the right situation, if he was really defending himself or really defending that other person, he would have had the right to do that potentially, but the castle doctrine didn't apply to give him that extra layer of presumption. So that, again, that's kind of what that does. It gives you an extra layer of protection, but it doesn't always work.
And in case it's not clear, I know we didn't talk about this, when it comes to the castle doctrine in your house, you cannot protect property with deadly force. So if I come into your house illegally, you didn't invite me, I grab your big screen TV, I really like it, and I run out your door, don't shoot me in the back. You're no longer defending yourself, you have no justification, you're just defending your property. there was a famous case where a guy's shed kept getting broken into, so he did what any reasonable person would do. He put a spring-loaded shotgun by the door, and his wife convinced him to do it leg level. And a criminal came in and broke in and got his leg blown off. He sued and won. Because you cannot defend property with deadly force.
Yeah, so the castle doctrine, part of that law is, it actually says, you're presumed to have acted in self-defense if the person against whom you're using that force is in the process of, is in the process of unlawfully and without privilege to do so, entering, so they're in the act of entering, or they have already entered without, and it's unlawful and without privilege. So you don't have to let somebody come into your house first. They're coming through the window. It's obviously, this is a burglary situation. You don't have to let them come in before you defend yourself, because it's only going to get worse for you once they're in the house. So that does protect you. And the easy cases, as Kevin would say, the easy cases are burglaries and things like that, home invasions where people are coming in. The really difficult ones are people that know each other that get in the arguments. I saw some questions, yeah.
Back to the TV or property, I understand that you don't want to blast somebody as they're walking off your TV, that doesn't make sense. But can you get them with some rock salt? That's not deadly force, right?
Well, I don't know if that would be considered deadly force. I mean, that's.
Go ahead, make new case law. I'm just kidding, don't do that.
Yeah, using deadly force, it's difficult to say that, You certainly, especially the case of somebody's grabbed your TV, they're already outside, they're not a threat to you, and they're running away. You don't shoot them in the back. Using rock salt, I don't know, it probably isn't deadly force, but it could be at a close enough range. Yeah.
That doesn't, the cancel logic doesn't cover like a repairman or something, does it? I mean, because you've let them in your house. If you call a repairman to repair something,
Well,
and go problem starts.
well, if they attack you in your home, I would say if they came in under false pretenses, it may well apply to you, but
You can't, yeah.
But in that circumstance, as long as you've got a legitimate self-defense argument, then you'll even need this.
Okay.
So what about RVs? Because that's considered a second home.
Sure, yeah, if you're in camping, because in Ohio it covers a tent. It actually says a tent. So yeah, that would be considered your home for the night or whatever, yeah.
An unattached building on your property, say a garage. if they
No,
attack you-
unattached buildings are not considered your abode.
Okay.
So you can still always defend yourself, but you may not have the castle doctrine. And again, as Kevin was saying, people have gotten into trouble by saying somebody's out in my shed stealing tools from me. I'm going to hang out the window and shoot them. You're defending property at that point. That's not your residence. You're defending property. Yeah.
Does castle doctrine also apply
Sorry, did you catch
to
that?
boats? Boats and marinas and harbors?
I'm not sure. It may, because it covers a car, but, I mean, what, would somebody be trying to come in to your boat to hijack it from you?
Well, sometimes you're out in Anchorage and you're by yourself and boats go by and, we always wondered whether someone had boarded boats.
I think
Not knowing the case law, I would say it's definitely at least akin to a vehicle.
and I think this, I'm trying to think what the language in the statute is. It actually says I think it says a vehicle. It doesn't say an automobile.
Some of them say watercraft too.
Yeah, but it may cover you, because I think it's broad enough that it's not just a car. I think it says vehicles for transportation. Were there any other questions? I think I saw one other hand.
People do it earlier too, if somebody's coming in the window. If you shoot them and they fall back out the window.
Leave them. I mean, okay. No. So, okay, so you've got that situation, somebody's.
looking to double that.
Yeah. Here's what you do. So they fall out. First of all, immediately you want to call the police anyways. So hopefully they're not currently a threat to you. If they're outside your house, you know, my view would be I wouldn't go outside. I'd call the police, stay in the house, maybe be by the window so they don't try to come in again. Call the police, make sure that you're safe. You don't have to drag them in or anything like that. What you don't want to do is make the situation worse. Because of the danger that would be involved, you're not going to go out and give them first aid, probably. That's why you'll call the police right away, tell them I shot somebody, send an ambulance, send the police. Don't make it worse. Don't go now hang out the window, they're still alive, and shoot them. You know, you don't want to do that. That happens, and there's video of that, of a guy in Michigan that did that. He was, if you remember a few years ago, I think it was 3 or 4 kids went into a pharmacy. They had guns. They were there to rob the pharmacy. The pharmacist had a gun, took a couple shots at him, hit the one kid went down, the other 3 ran out. He ran outside after him. I don't know if he took a couple shots at him, but I don't think he hit anybody. The kid was still on the floor. He was out. He wasn't dead, but he wasn't gonna harm anybody. The guy, he must have unloaded his gun because he went back, either he got another gun or he reloaded. But I know that was part of it, is he actually reloaded or got a second gun that he had, went out, shot the kid that was laying there twice, killed him. He was charged with and convicted of murder. So you can't make the situation worse by, once there's no threat to you, don't keep shooting, but you know, keep yourself safe. But hopefully that answers your window question. So yeah, if the prosecutor provides sufficient evidence that you weren't acting in self-defense, they can overcome the castle doctrine. But again, it's going to be facts and circumstances, the total circumstances to get there. You know, and as I said, invitees, kind of guests turn bad, those are all complications with the castle doctrine, and the castle doctrine may not apply. Again, doesn't mean you can't defend yourself, but you know, the castle doctrine may not apply. You just have to, you know, they may have to the prosecutor may have to overcome your claim of self-defense as long as there's some evidence that you were acting in self-defense. There was another case up in Cleveland. You know, you're talking about earlier, you know, drugs and stuff under the disabilities. Guy was a drug dealer. I'm sure he had lots of money and drugs in his house, and a couple guys came in it was a home invasion to rob him. They shot and killed at least one of them, and he claimed self-defense, and he got off. Yeah, it was a justified shooting. They got him for all the drugs and stuff, but you know, it was a justified shooting. So you know, that's happened. I think you did claim castle doctrine on that.
Okay.
Yeah. So, and Kev talked about it earlier, defense of others, you can certainly do it, but it's fraught with problems because you have more right to use deadly force against somebody than that person that you're defending, you think you're defending, had a right to use. So if they were the initial aggressor, or if they say, I wasn't afraid for my life, you had this all wrong. You know, I wasn't afraid, I know this person, and we were just having some fun. You know, you go and shoot somebody where you don't know the situation, even though you think that you're doing them a favor, it can be bad news for you. So you want to be a good witness, get out your phone, do whatever you need to do, you know, tape it and be a witness, but unless you know what's going on, you can get yourself into a lot of trouble by, you know, stepping into the middle of an argument where the other person may be the aggressor that you think you're defending. We already talked about it. You can't defend property alone with deadly force. So you see somebody out in the driveway stealing your car, again, you can't shoot them for doing that. Technically, under the law, you could go out and make a citizen's arrest. That is a legal thing. They're committing a felony. You could arrest them, but you're opening yourself up to a whole lot of potential, threats. You don't know if they've got a partner that's watching out for them. You go out and somebody hits you in the back of the head or shoots you in the back, whatever happens. So again, you want to make sure that you don't try to do something like that. Somebody has already gone from your house, has stolen something, and they're no threat to you. The Castle Doctrine isn't gonna cover you. Again, I do encourage you to look at the Ohio Attorney General's book. We're about out of time, and I'm to then to any questions. Yeah.
Case in Texas where a lady was in a restaurant, people came in and started shooting the people in the restaurant. Does she have the right to engage those people, try to neutralize the threat?
I would say yeah, because I would say she's
not personally being.
Well, they may get to her.
Not yet.
Yeah, I mean that is, again, it's a facts and circumstances type of a situation. If it looks like somebody is getting ready to just wipe out the whole place, or that now that you're a witness, they're going to take you out too. It's probably a pretty good bet. You hope the case isn't that all of a sudden, if it's FBI coming in, they're probably going to have FBI in the back of their jackets. You're going to have to evaluate that and see. It's probably a good shooting, but you have to look at it, make an evaluation in a second. Yeah.
So, if I understand the process correctly, when you're applying for your CCW license, a training certificate is going to be requested that you went through that training.
Yeah, if you get a license from the sheriff, you still have to have the training.
And one of the options is from certified instructors.
Correct.
Is there a list that can be found who those instructors are?
I think you can. I think if you Google, instructors, certainly you can go on the NRA website. You can go on some of these other organizations, the USCCA.
The Ohio Attorney General also has a list.
They do? Okay. Or a lot of the gun stores around them. Cuyahoga Falls, Norton, where's other gun stores? They'll hook you up with instructors.
Yeah. We own homes, we own vehicles, and we carry insurance. Is there a special insurance that a permit holders should carry?
Talk to your insurance agent. Typically, your homeowner's policy and an umbrella policy should be enough, but it depends on the particular company that's insuring you. I've heard about these companies. There are companies out there that talk about self-defense insurance. I've heard mixed reviews of those, and I don't really know a lot about them. So they're out there, but be careful. I would rather go with a reputable large insurance company, get an umbrella policy that's going to cover you for a negligent shooting, some negligent act with a decent umbrella policy. It won't cost you a lot of money. That's probably the way to go. Talk to your agent though and say, look, I'm going to be carrying a concealed weapon. I want to make sure I'm covered so they know what they're looking at. Yeah.
What about an instance of like road rage, or say you're at a red light or something, you don't start out fast enough and somebody decides to start beating on your car with a baseball bat, breaking your window?
Well, first of all, if you can drive away, do it. There's going to be lots of different opinions on that.
Yeah, sorry about that. I was just angry. No, I'm just kidding.
Yeah, it's hard to say. You're gonna have to make a split-second decision. Is my life really in danger? You're gonna have to go back to that, and that's part of the problem of carrying a gun. Now you have to possibly make these split-second decisions. I mean, it's just the fact of life carrying a gun. I can't give you a real good answer. You're gonna have to say, my life is in danger, or is this guy just an idiot and I can drive away, or he's an idiot and then he's gonna walk away? Don't know.
I mean, a lot of times somebody could block you in and you can't.
Marvin, would you
Yeah,
jump
yeah,
in there for a second?
Yeah, go ahead.
That's actually exactly what I was gonna say, sir, because all those little facts will make up a big deal. If someone's blocking you in, you gotta know where to go, you felt like you were trapped. I mean, when we look at cases, every one of those details are very, very important. The one thing I want to say, because as I told you at the beginning, this is the favorite part of the presentation, right? So we start talking about every possible scenario. Now, the best thing I can tell you is this. We are prosecutors, which means that we have to convince 12 people beyond a reasonable doubt that a crime happened. And then, if the crime did happen, we have to prove that it was not self-defense. When we talk about that, the best analogy I can make is, imagine going to the 6 Acmes in Summit County, grabbing 2 people from each Acme, putting them in a room together, and now convincing them where to have dinner. And now I can convince those 12 people. I don't mean to make light of it, but when we're talking about self-defense, a lot of times it's the jury that makes that determination. And I started by saying this is something that we're still wading through a lot. With the change in the gun laws, with the change in the self-defense laws, we don't have hard and fast answers because these laws have only been changed in the past couple of years. And we are still getting different answers from juries. As I said, last 2 cases I tried. A murder case we won, self-defense. A felonious assault case I lost, self-defense. And I thought I had good cases in both.
I mean, I can understand if you're at a gas station, somebody comes up and taps on your window with a gun, I'm getting out and saying, here, tap the car. But if you don't have a choice, I mean.
Well, you know, that's a fact that would go into that. Somebody is pointing a gun at you. Well, first of all, you just give them your car, or if you say, for whatever reason, maybe they get distracted and you could shoot them, that is probably a good self-defense. Somebody points a gun at you, they've crossed the line. So, but again, there's going to be all kinds of facts and circumstances. Yeah.
Summit County, I was told if you have an honorable discharge DD 214, you don't need that training.
I think that's correct. As long as it has firearms training on it. It has to say, I forget what it has to say, but yeah.
I don't know the actual verbiage, but as long as your DD 214 says that you were firearms trained or certified while you were in the military, then you're good.
Yeah. Yeah.
Do veterans have to pay anymore? Was there a change to that?
I don't know the status. The last time I looked, as long as they haven't reached the dollar limit for the state, you don't have to pay. There is a dollar limit in total, which is kind of crazy, but chances are you won't, because actually license applications are way down.
Are you the ones responsible for moving, if you see a weapons sign-up place out of the jail?
Yes.
Yes.
Thank you.
Look, they serve a great neutral.
Yeah. Yeah.
Where do you find the steps? Every step that you have to get the CCW?
The application is on
The sheriff's website.
Sheriff's website, and I think I think there's one actually at the back of the AG's in a written form, because if you go through the website, I think you kind of have to fill it out as you go.
Yeah.
You're not gonna, but it's fairly easy. Do you still have to have a photograph?
Yeah, but you can, so, we have little cards out there that have a QR code, you know, that.
I have the app on my phone.
Okay, if you have the app.
I just thought, is there, like, you have to take a gun safety course or something before you can apply? So that's what I'm
Yes.
saying, what are the steps before you do that?
You wanna go take your gun safety course, and then fill your application out.
Oh, that's it?
Yeah, that's it.
Okay.
Yeah, just go sign up for a class at a. Sorry.
And the app, you can upload your picture, you can fill the application out, all of it. Right, you can do it all online, and then we'll do your background, and then we'll call you.
Awesome.
You can even pay online. You don't, the last thing that you'll have to do is physically come though, and you have your ID.
Yeah.
If you're a veteran, active duty reserve, retired, or honorably discharged, there's no fee to apply.